The GDPR catches data controllers and processors outside the EU as well, whose processing activities relate to the offering of goods or services, even if for free, to or monitoring, of course, the behavior of EU data subjects within the EU. So many will need to appoint a representative in the EU. So offering goods or services is more than mere access to a website or email address, but might be evidenced by use of language or currency generally used in one or more member states, with the possibility of ordering goods or services there and or mentioning customers or users who are in the EU. So monitoring of behavior will occur, for example, where individuals are tracked on the internet by techniques which apply a profile to enable decisions to be made or predict personal preferences, profiling. So this means in practice that a company outside the EU, which is targeting consumers in the EU, will be subject to the GDPR. So this is not the case currently and will have a huge impact on global companies and economy. So the GDPR places onerous, most of all, accountability obligations on data controllers to demonstrate this compliance. In certain circumstances, data controllers and processors must designate a data protection officer, so-called DPO, as part of their accountability program. So the threshold is processing that is carried out by a public authority. The core activities of the controller or processor consist of processing which by its nature, scope or purposes require regular or systematic monitoring of data subjects on a large scale, or third, the core activities consist of processing on a large scale of special categories of data. So the DPO will need sufficient expert knowledge, that's for sure. This will depend on the processing activities for which the officer will be responsible, and the DPO may be employed or under a service contract. Another topic of huge debate relates to parental consent being required for children to receive information society services. The compromise member states can lower the age from 16 to 13 will result in a lack of harmonization, that's for sure, in companies who operate across several member states, generally choosing to meet the highest standard. So the recitals provide, however, that parental consent is not required in the context of preventative or counseling services offered directly to the child. That's a side note. One of the key changes in the GDPR is that data processors have direct obligations for the first time. These include an obligation to maintain a written record of processing activities carried out on behalf of each controller. This designated data protection officer will required, obviously, as I said before, appoint a representative when they are not established in the EU in certain circumstances, and notify the controller on becoming aware of a personal data breach without undue delays. So that's some of the new regulations. The provisions on cross-border transfers also apply to processors. Important BCRs for processors are formally recognized. The new status of data processors will likely impact how data protection matters are addressed in supply and other commercial agreements, obviously. So data controllers must continue to provide transparent information to data subjects. This must be done at the time the personal data is obtained, very important. However, existing forms of fair processing notice will have to be examined, as the requirements in the GDPR are much more detailed than those in the current directive. For example, the information to be provided is more comprehensive and must inform the data subject of certain of their rights, such as the ability to withdraw consent and the period for which the data will be stored. Controllers will need to consider their forms of fair processing notice with these new obligations in mind and check in that they are providing the information in a clear way and in an easily accessible format. Data controllers must notify most data breaches to the DPA. This must be done without undue delay and, where feasible, within 72 hours of awareness. Reason justification must be provided if this framework or this time frame, I should say better, is not met. In some cases, the data controller must also notify the affected data subjects without undue delay. notification does not need to be made to the DPA if the breach is unlikely to result in a risk to the rights and freedoms of individuals. The threshold for notification to data subjects is that there is likely to be a high risk to the rights and freedoms. While this may lessen the impact, all companies will have to adopt internal procedures for handling data breaches in any case. The GDPR establishes a tiered approach to penalties for breach, which enables the DPAs to impose fines for some infringements of up to the high of 4% of annual worldwide turnover and 20 million euro, for example, breach of requirements relating to internal transfers or the basic principles for processing, such as conditions for consent. Other specified infringements would attract a fine of up to the high of 2% of annual worldwide turnover or 10 million euro. A list of points to consider when imposing fines, such as the nature, gravity, duration of the infringement, is included in the GDPR. Welcome change for data controllers is the removal of the general requirement to notify the DPA of a controller's data processing activities and to seek approval from the DPA in some circumstances. The aim appears to be alleviate the associated administrative and financial burden on data controllers, but it will mean DPAs in some countries will need to replace this source of funding from elsewhere. So instead of general notification, the policy is now to require data controllers to be accountable for their data processing. One example of this in the GDPR is the obligation on data controllers to put in place effective procedures and mechanisms focusing on more high-risk operations, for example, involving new technologies, and carry out a data protection impact assessment to consider the likelihood of and severity of the risk, particularly with large-scale processing. The effort required and the potential fines for getting it wrong are likely to outweigh the benefit of the removal of the administrative burden of the general notification requirement. In addition, there's a new requirement to consult the DPA in advance where data impact assessment indicates that the processing would result in a high risk if measures are not taken to mitigate that risk. If the DPA feels that the processing would breach the GDPR, they may provide written advice and use their enforcement powers where necessary. So this obligation creates uncertainty for data controllers, that's for sure, as they will have to assess the outcome of the impact assessment and decide whether to consult. Now, data exporters who rely on consent to move data outside the European Union will need to look carefully at whether data subjects have been sufficiently informed of the risks of transfer.